membership that Ms. Rhodes before has mentioned to you, to become part of this network, this group of 16,000 members in 40 countries across the world, who has the gold standard as a professional body resolution in domestic dispute resolution across all of the continents. The Nigerian branch is a model. The level of engagement, the number of conferences that it organises, it's a credit to the work that's put into it. And it's people like Chief Bayo Ojo who have been working over the years to build this up to the very strong, perhaps one of the strongest branches within the institute that we have. Why would you involve your the international bodies and to the domestic bodies and the people that I've met during my year is that as you appoint new people, and you must appoint new people to keep the cadre going, you can't rely on the same people all the time. New people must come in, and hopefully as they come in, that will add to diversity in a number of ways. If you appoint one of you, if you appoint a member, a fellow, a chartered arbitrator, because then you're appointing somebody who's trained, who's qualified, who's educated, who has been assessed in their abilities in that role, and who have the support of a network of colleagues, and who also have the support of the Institute with the guidelines that the Institute presents to us to allow us to do our work, and has the support of the CPD, the continuing professional development processes and events that are organised by the branches and by the young members group and so on. And importantly, it's regulated. So in the event that if somebody, in the highly unlikely event that anything wrong happens within a process, well then there is someone to go to, there's the Institute to go to complain, and we have our disciplinary procedures. So I'll finish by saying that young members, it's you who will lead the Institute into the future. The Institute won't lead you into the future. We see that already with the use of technology. Your questions and so on. I'm hoping that soon you'll be broadcasting this to the world. There's no reason why the technology is there, why this cannot go online, and that to be standard. So all the work that these different committees put in will benefit by not only being to 100 people, but to thousands of people, hopefully, who can log on to get the event. And that's very, very near. That's coming down the line very, very, very soon. And innovation comes naturally to young people. It's young people will lead us into the innovation and into the change. Young people don't have to think about innovation, they do innovation. And diversity is also something that comes naturally to young people, because whereas diversity is a new idea for perhaps older generations, it's just standard for my I hope we get to talk over the next few days, and I hope to come back again when I'm a less important person.
I'm going to introduce the moderators and the panelists before I read out the scenario. So we have Mr. Mofe Tayo Oyetibo. Please come up. Miss Joke Aliu. Mrs. Mr. Kole Mayomi. And Mrs. Oluwakemi Eweje. Arbitration scenario. I believe we all have one. We all have a copy. So the parties are Let's Chat Limited of Nigeria versus Sinosoft Development Corporation of China. The background. Involved in the business of creating and developing mobile apps on both the Android and iOS platforms. Let's Chat and Sinosoft entered into a software development agreement for the development of a social media app called Beam. The app is to cater specifically for Gen Z. It will have an innovative digital hangouts feature, which allows friends to hang out in virtual reality, irrespective of their actual location. It will also increase brand participation with its artificial intelligence systems Jarvis, which enables brands to offer personalized shopping experiences to the app's users. To generate interest in Beam, Let's Chat invested heavily in, amongst other media, the services of social media influencer Lindy Ikeja. The marketing campaign is paid off. The marketing campaign paid off. After the first month alone, the Beam app had over 1 million pre-orders, and Let's Chat secured advertising commitments from numerous major brands worth several hundred thousands of dollars. The contract. The SDA is governed by Nigerian law. It has a non-compete clause prohibiting Sinosoft from developing or selling competing apps. It also has a dispute resolution clause providing for claims to be settled by arbitration in Abuja under the Arbitration and Conciliation Act of 2018. There will be 3 arbitrators, each to be appointed by the chairman of the Royal Institute of Chartered Arbitrators, London, Nigerian branch. The dispute. The dispute arose when Let's Chat alleged that Sinosoft breached the SDA by developing a mobile messaging app called EvoChat for a competitor, AR Labs Limited. EvoChat allows users to take a selfie with friends and celebrities projected via augmented reality. It allows brands to project their products into the homes of the app's users through special filters. Let's Chat has submitted a notice of arbitration under the Arbitration and Conciliation Act of 2018. The notice of arbitration included an application for emergency interim relief pursuant to Section 16 of the Act to prevent Sinosoft from developing evil charts pending the arbitration. The application is addressed to the chairman of the Chartered Institute of Arbitrators Nigerian branch, who has since appointed the emergency arbitrator. In response, Sinosoft has raised a preliminary objection on the competence of the arbitration clause. It also contends that EvoChart is a completely different app and that Let's Chart's losses are quantifiable. A hearing has been fixed for 24th of October 2018 in Abuja, Nigeria. The proceedings have quickly become contentions and millions of dollars are at stake. So now I'll read excerpts from the software development agreement. This agreement is dated February 6, 2018 between Sinosoft Development Corporation, incorporated and registered in the People's Republic of China, with company number 31-4-645050, whose registered office is at Raycom Infotech Park, Tower C, North Building, number 2, Kixuyan South Road, Haidian District, Beijing, PR China. Let's Chat Limited, incorporated and registered in the Federal Republic of Nigeria with company number RC 109876, whose registered office is at 1357 Adetokunbo Ademola Crescent, Wuse to Abuja FCT, Nigeria. The customer. Services and Systems Development, Clause 4. In consideration of the fees described in Clause 5, the developer will provide the customer ongoing software development and consulting services in the following areas, collectively known as the services. The developer will develop, maintain, customize, distribute, and manage the system configuration, provide 24-hour emergency response, tests, and provide second-level support, and provide user and technical documentation for the Beam social media app. The non-compete clause, Clause 8. In consideration of the payments made by the customer to the developer in this agreement, the developer agrees not to develop, design, code, test. The developer covenants and agrees that it has no right to market, distribute, sell, or license any of the applications or deliverables being developed under this agreement. Additionally, the developer covenants and agrees that without the prior written enter into any discussions with any party with respect to the foregoing applications and deliverables for a period commencing on the date of this agreement and terminating on that date, which is the third anniversary of the acceptance by the customer of the last deliverable provided under this agreement. The arbitration clause, Clause 15. Any dispute, controversy, or claim arising out of or in connection to this agreement or the breach of it shall be settled by arbitration in Abuja under the Arbitration and Conciliation Act of 2018. There will be 3 arbitrators, each to be appointed by the chairman of the Royal Institute of Chartered Arbitrators, London, Nigerian branch. The governing law. This agreement and any dispute or claim arising out of or in connection with it or its subject matter or formation, including non-contractual disputes or claims, shall be governed by and construed in accordance with the laws of the Federal Republic of Nigeria. So I'll now hand over to Isaiah and Kemi.
Thank you very much, Deborah. Well, welcome everyone to this second YMG conference. And as Deborah was reading out this scenario, I'm sure your mind was already going towards some areas that could lead to potential disputes. And in fact, as Deborah was introducing the panelists, I suspect another dispute might be brewing, because Mr. Aliyu might take issue with her demoting his wife from Mrs. to Miss. But we'll deal with that. We'll deal with that issue later. Now, welcome again. Just a few housekeeping rules before we go into the discussion. As a courtesy to the speakers, please ensure that your mobile phones are either off or on silent, so it doesn't distract them as they're making their interventions. Secondly, there is Wi-Fi available. The Wi-Fi will be displayed periodically on the screens. It's on there now. So if you haven't done so already, please ensure you join one of the Wi-Fi networks. You will need it for the next part. Finally, this conference is different in that we, as much as possible, want to hear what you think. So essentially, you, the audience, will be driving the conversation. So in order to facilitate that, we'll be using an audience interaction platform called Slido. You've probably seen several emails already, and you're probably sick of hearing the name Slido, but you'll finally get to use it now. So please take out your mobile phones, your tablets, get your devices out, but keep them on silent though. And take your web browser and go to slido.com, slido.com. And when you get there, it will ask you to enter an event code. The event code is CIArb-NG. Okay, so I'll just give everyone a moment to log in. So go to slido.com and enter the event code CIArb-NG. And you can just give me a wave when you've done that, so I know that some people have logged in before we move forward to the next stage. Oh, great. Okay, we have a couple of people logged in. So when you log in, there will be a warm-up poll waiting for you, right? And we want you to answer this question, which will determine the way the conversation goes. So when you log in, I would like you to tell us on which of these areas do you need the most guidance? Do you need the most guidance on avoiding or managing pathological arbitration clauses? Do you need the most guidance on what criteria do I consider in selecting an arbitrator? Do you need the most guidance on, for instance, when should I make a jurisdictional challenge, or should I make a jurisdictional challenge in the first place? Or do you need the most guidance on evidence in international arbitration? You can start voting, by the way, so you can pick the ones you need the most guidance on. Or do you need the most guidance on developing and implementing a case strategy? Okay, so we have one vote, and that person wants to know about the timing of jurisdictional and other challenges. Okay, I'll give you a few moments for the votes to collate. So we'll see which areas interest you the most. It seems case strategy is winning at the moment. Incidentally, that's Dr. Ekweme's intervention, but we have a very capable panel here who I'm sure will do justice to it. So it seems we have a clear lead in developing a case strategy. And if I was voting, this is what I would choose actually. Because imagine your principal in the office gave you a file that contains this contract, and for instance, it says there will be a client interview at 1 o'clock at the office. What do you do then? What stages do you do? So, Kola, I wonder if I can come to you first on this question. If for instance, Mr. Ajibade comes up to you and says, Kola, this is the situation, we have a client interview. How do you develop the factual matrix, the facts that the client narrates to you? How do you develop that into an initial case strategy going forward?
Thank you very much, Osai. We have a very interesting set of facts, and your question is how do we develop that into a strategy? From the set of facts presented before us already.
Any facts?
Any facts at all?
What steps? So what steps, if you're presented with any set of facts, irrespective of whether it's this case
Yes.
or another
Yes.
dispute,
Yes.
how do you translate what the client says to you at that initial interview to start building your case strategy? Do you, for instance, develop a theme based on what he has said or
Yeah.
what she has said? Do you then sort of start
Yes,
your
thank
factual
you.
investigation, that sort of thing?
Thank you. I mean, obviously, your factual investigation must come first. Because no matter what a client comes to say to you, if you don't take your time to distill what he has said, what he or she has said, into what you can actually litigate or what you can actually present before a tribunal, you might be walking into an embarrassment. So to prevent embarrassment, factual investigation comes first. Now the client has presented me with these facts or any set of facts. Do you have documents to corroborate everything you've said? Then there's something that I do. All the documents that are put before me, that all the clients bring, I'll put them into a timeline. The earliest documents showing the trail of events, the train of events, what happened first, then this happened, then this happened, then this happened. Then I'll now re-engage with the client and said, okay, now that we have the facts in order, divorced from some of the spins, because a client will not tell you 100% the truth. The client will always put a spin on it and will be tied a counsel that takes anything that the client says at face value. So after you've done your own factual investigation and said, this is the case, this is the course of action, then, I mean, again, looking at these, other strategic considerations like what kind of arbitrator can I appoint? Does it make sense to file a jurisdictional challenge? Does it make sense for the proceedings to go on, or probably some people will say she would rather have our day in court? So these are some of all the other considerations that will come into play after the factual matrix has been well identified and after the course of action has been identified. Because, for example, in this, you can also see a course of action of probably copyright, trademark. I mean, there are all sorts of other considerations that may go into it, and you may well be advised to first go to court to probably get some injunctive orders to restrain the infringement of the software infringement before you come back to actual arbitration. Again, it's all a matter of strategy.
Okay.
Okay, thank you, Kola. I couldn't help but watch Joke jot some things down while Kola was talking. So I think she's a strategic person, and she's a strategy expert. So Joke, to you now, is there a checklist that one must have when preparing our strategy? So irrespective of the facts of the case, can we have like a checklist that would guide us? You know, you don't have to say the whole thing. I know you have like a textbook of it, but take notes down.
I mean, I think it's important to have something like a questionnaire and a checklist. The checklist would always work well so that you can tick your boxes, I mean, as time goes on. But let me also take off from where Kola started, which is